Call the third case on this morning's docket, case number 115119, State of Kansas v. Charles Williams.
May it please the court, counsel, I request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Mr. Williams got into an argument with his stepson and stabbed his stepson, and the stepson eventually died. This case resulted from that. Mostly it's procedural that we're going to be talking about today. Mr. Williams was charged with reckless murder and then eventually intentional second-degree murder. There were several continuances for trial requested by the state, by the defense attorney. He was convicted, and then on appeal, that conviction was reversed. He was convicted of second-degree reckless murder. The conviction was reversed, went back for another trial. He was again convicted of second-degree reckless. Prior to sentencing, he raised an issue that his speedy trial rights expired before the state brought him to trial in the first trial. And the district court ruled that it was too late for him to raise that claim. He should have raised that before. And the judge sentenced him. And after the first trial, the judge granted a downward departure. After the second trial, a different judge said, I don't have to give a reason why I'm giving a presumptive sentence, so I'm going to give you the presumptive sentence, which was 400 some odd months. And the Court of Appeals affirmed. We raised an issue of the speedy trial and that this was a vindictive sentence by the judge. The Court of Appeals affirmed that. This court granted review on those two issues, and then I raised another issue on sentencing that Mr. Williams had a unnatural intercourse conviction from Mississippi that was scored as a person felony, and we argued under Wettrick that that conviction should have been scored as a non-person felony. And so that's where we're at. I'll just start with the speedy trial issue. There's a lot there, a lot of procedural stuff. Obviously, as always, the court I'll talk about whatever you want to talk about, but I'll just start talking with the speedy trial. The first issue on the speedy trial is whether it is the claim is barred by res judicata. The district court didn't specifically use the term res judicata, but that seemed to be how I interpreted, how the Court of Appeals interpreted his decision, that you should have raised this before. And the Court of Appeals noted that on any, in finding it was res judicata, there are four parts to it. Same claim, same parties, that the issue was or could have been raised before, and that there's a final judgment. And what we take issue with was the fact that there was a final judgment in this case. A case runs from when the defendant is charged until the convictions are affirmed. And there can be many hearings and results in between that, but there's no final judgment of the case. The Court of Appeals, I did not see where they said exactly what the final judgment was. And I believe the most logical thing would be this court's mandate from the first appeal, that would be, I think that's what they're using as a final judgment. And that's not a final judgment. And this court considered the matter in State of Katy, and where a person was convicted, appeal got reversed, case got reversed, went back, and then at the second trial, he tried to suppress his confession. And so the question on appeal was, well, he should have raised that before. And this court said, no, if an issue can come up again, if it can arise again, then res judicata doesn't apply. Which that says to me that the mandate of this court is not a final judgment. Because if it was a final judgment, then it wouldn't matter if it could come up again. That's sort of the nature of res judicata. It prevents things that come up again. And so that's not a final judgment. And so we would argue that the claim is not barred by res judicata, and this court should consider his speedy trial claim on the merits.
And you're saying if there was a violation on the first trial, that violation would carry over because it was a do-over, and the case continued with the second trial, and so it's still the same case. That's your argument.
That's it's still the same case, and at some point during that case, the state became, prosecution became time barred because of the statute of the speedy trial.
It seems to me that we've had a case where there was some delay after a remand, and so when you start adding up days, that they accumulate.
Right, and
You have the clock stops when you appeal and then come back for a reasonable time, but there's a point at which we have said the clock starts again, and it doesn't start with day one, it starts with where they are at that point. Isn't that, am I remembering correctly or not?
I think that sounds right. I remember it in the context of a motion to, a defense motion or something like that, and it starts. Nonetheless, I think the difference in those cases, if I'm remembering correctly, is that the time had never run. And once the time runs, then it's barred. And I understand that there's a statute that says, okay, if it's remanded, the state has, I think it's 90 days, I think it's still 90 days, to bring him again. And that's a new clock. That doesn't purge or absolve the state of any prior speedy trial violations.
On your res judicata argument as to what's a final judgment, is the implication of that anytime there's a remand, everything's back on the table? So the defendant, for example, could refile the exact same motion to suppress and relitigate it. Is that that seems to me to be the implication of
Well, there's law of the case, right, would still apply. And if the matter was litigated and this court said no, then you have law of the case, which is a different doctrine, and only applies to those issues which were in fact raised, which doesn't apply here because it was never raised. So I think if they filed a motion to suppress and this court said that it should have been admitted but we're reversing on instructional. If it goes back again, the law of the case would be that that suppression is admissible. And unless new evidence comes in that would change that ruling or something, then I think that ruling would still apply under law of the case. The law of the case doesn't apply here because law of the case is restricted to issues that were actually litigated and ruled on.
What about garden variety preservation? Just didn't raise it in his first appeal. Why doesn't that constitute some kind of a waiver at that point?
Okay, so just
that doesn't require that it have been actively litigated. That's just final preservation.
Right, and I think so we're moving away from res judicata.
Yes, I'm not talking about
That's fine. That's fine.
law
That's
of
fine.
the case, because those both
clarify.
have the requirement of either being previously litigated or could have been raised. So let's not talk about those. Let's talk about just regular. If he were any other defendant who failed to bring it on his first appeal, that would be a problem for him, wouldn't it?
Yes, that's right. But I think it is still you have this period of the case, the full case. Mm-hmm. And so the question is, as this court generally, is there a point during the case, if you don't raise it in a timely fashion, is it waived? For example, this court doesn't require, if the speedy trial runs, it doesn't require that you waive it if you don't bring it before trial. You can still bring it in your motion for a new trial. Mm-hmm. And so the difference, I think, in those cases, it's not a waiver issue as much as it's still a res judicata issue. As long as you're in the case, that it doesn't seem like just the passage of a time or a hearing constitutes a waiver of the speedy trial issue. I don't see anything particular about appeals. Now you can abandon that, and actually, yeah,
maybe abandonment is the right name, rather than waiver.
But that appeals to whether this court does consider it and can consider it. And certainly, if the court would have affirmed his convictions, he'd be out of luck. But it didn't, and the case continues on.
I understand your final judgment.
But
I think there are a lot of issues that might fall under that final judgment isn't really rendered until after the appeal's completely finished and whatever happens on remand is completely finished.
Yeah.
But it seems like there are it seems like this would open the door to a lot of issues that could be brought up on the second go round, even though there was no complaint about them in the appeal after the first trial.
Right, and I understand this court doesn't want piecemeal, but I think it's also somewhat of a draconian remedy to say for somebody like Mr. Williams that, yes, your speedy trial rights were violated, but
Isn't part of the problem that we don't know? I mean, there's a practical element of this in that the claim, your client's claim has at least some degree of fact finding required. And we're further down the road, memories fade, all those reasons why we want to determine fact questions as close to the time as possible come into play.
I think that's true. At the same time, I think for this, it's less of a, and maybe that goes into the waiver. In this particular issue, I don't think there would be, there are fact questions that need to be determined, but it's really, was he at the hearing or was he not? And I suppose people could die, but other than that, it seems like that would be something that wouldn't fade with time as much as maybe some defenses or those type of things. As to on the merits of that, this court, I'm driving straight into the teeth of Dupree on this, because this court has previously decided that because what happened was the time period where it ran, it would have expired. The state's opportunity to bring him to trial would have expired before the change in the law that said that if there is an error, if delay is misattributed to the defense and it should have gone to the state, you don't get relief. And this court said that that's not a vested right, therefore it doesn't matter whether it has expired before the deadline or after, before the change in law or after the change in law. And I cited Stogner v. California, which was a statute of limitations case, where they said that if it expires before that, the ex post facto clause applies. And Dupree, the case I was talking about before, I'm not sure if the parties raised ex post facto. It didn't appear that it was discussed in the opinion. So we're talking about the ex post facto clause, and it seems to me that the question is, because that was a statute of limitations case, is there some material difference between the statute of limitations and speedy trial that would render Stogner inapplicable? And I don't think there is. In fact, Dupree talked very favorably about statute of limitations, comparing them, that these are very similar. Statute of limitations and speedy trial are very similar, as opposed to a statute of repose, which is there are no exceptions and those kind of things. So it seems to me that that Stogner would apply, and that Dupree should be overturned, and that it should be Mr. Williams' conviction should be vacated based upon a speedy trial. On the sentencing issue, he had a Mississippi unnatural intercourse conviction, which was scored as an ag crim side. And I don't believe the state has made any argument that under Wettrick that it was properly scored as a person felony. Where the question is, can we raise this now, and whether the new statute under that says that sentence which is legal at the time is cannot be corrected under a motion to correct a legal sentence. This court in Murdoch, may I finish briefly on to address Murdoch?
Yes.
Thank you. So Murdoch said that, as generally, as I understand it, that a sentence which is legal at the time it is pronounced is legal, is not an illegal sentence. So the question for this court is really was Wettrick a change in the law? And if it was a change in the law, then Mr. Williams' sentence was legal at the time it was pronounced. But this is just direct appeal. And in Murdoch, the court explicitly said that you get the benefit of a change in the law. If his sentence, if Wettrick was not a change in the law, then his sentence was illegal at the time it was imposed, and this court can correct that at any time and should correct it to a person felony, which renders the vindictive sentence question moot.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, Assistant District Attorney on behalf of the state. Starting with the first issue regarding the speedy trial claim.
Counsel, I don't think you gave us your name. You gave
I'm
us
sorry,
your
did I
position.
tell you? Julie Kuhn on behalf of the state.
Thank you.
Sorry, Your Honor. Regarding the speedy trial claim, it is our position that this is a claim. His claim is specific to the first trial. It is not, by my reading of his motion and what's been argued, he did not argue it connected to his time in the second trial. And our position is that if you want to complain about your speedy trial right for the first trial, he should have brought it during his first jury trial or post first jury trial in a motion post trial in that direct appeal, or even once the Court of Appeals reversed his conviction and sent it back for a new trial. Possibly he could have complained about it then, but he didn't at any of those times. And our position is he abandoned that claim. Furthermore, in the speedy trial statute, it indicates that when a case is reversed and sent back for a new trial, that the clock starts over. And so our position is that because of the language in that statute, and that he failed to raise this at any time in the first trial proceedings, that it has been waived or abandoned.
Do you think that if I realize you disagree with this, but if the speedy trial time period had expired in the first case, would the state still be able to prosecute the second case?
I know we're talking if. First, I don't agree that it did expire.
Right, you're not conceding that. I'm
Right.
just asking hypothetically.
I believe it would have had to have been raised, and that's to indicate something's going. You have to raise it for.
I
it
just
to be-
asked the question
to be
because
reviewed.
you recited your interpretation of the statute that it gives the state a new time period.
Mm-hmm.
But if the first time period had expired, that statute wouldn't save the case for the state, would it?
Candidly, I don't know that specific question has been addressed by this court, and that's where we go back and point back to that statute, because for the state it seems contrary to common sense to argue that after the completion of the second trial, the period related to the first trial was a speedy trial violation. It seems that would need to be raised in a timely manner prior to going all the way down the road when we've been up and back and now we're in a new trial setting and we've already had a full second trial, and then this issue comes before the court.
Counsel?
Yes.
The question, of course, is timeliness. How do we define timeliness for this particular issue? And I agree with you that generally speaking, if there's an error, the defense needs to speak up to preserve it. But haven't we also said that speedy trial is the state's obligation? That a defendant need not object? The state still has state and the court have an obligation to get a defendant to trial on time?
I would agree. We do have an obligation, and
Does
the
that
court
change
does have an
that
obligation.
analysis of abandonment or waiver here?
I don't think so, because I think we're also dealing with the situation, which was pointed out. We don't, there are factual circumstances because the district court did not rule on this on the merits. It just said it couldn't and basically similar to abandonment or waiver.
Counselor, I think the question is it waivable? What we're asking about is speedy trial waivable? And I think your answer is we do it all the time when the defense wants to delay the trial.
Yes.
And, okay, I'll appoint you new counsel if you waive your speedy trial
Yes.
rights under the statute. So your answer is that, yeah, it is waivable.
Yes.
And then the next question is, does that mean that it's amenable to abandonment?
I think it is, and you're correct. The defendants do that all the time. Either they want new counsel or they need more time, and so they are willing to waive that. And I believe that can tie in to the abandonment, that this was never brought. One would think that if a defendant believed his speedy trial rights were being violated, that he would want to raise it. And I know he doesn't have to raise it before trial, but that he would want to raise it as soon as possible, because if he is correct and his rights were violated, then he doesn't have that trial, or that conviction doesn't stand. He would receive relief.
Is there a time limit for when the defendant would be required to file such a motion, or a number of events that would have to transpire? For example, let's say he did not raise this after his second trial. It came up to the Court of Appeals. The Court of Appeals reversed and sent it back for a third trial. Is it your position that he could then raise for the first time his speedy trial right from the first go-round?
I think we're still getting the further away he gets from that first trial, I think the less ability he should have to raise it that far in time. And it does go to the situation that was mentioned. Now that you're that far out, saying you're at third trial and you want to complain about speedy trial at the first trial, you are now years down the road, assuming. I mean, this case, I wrote the first brief before my daughter was born. She's now 5. So that just, we all know how long these take. So memories can fade. If you have to make factual determinations regarding whether someone was there, whether defendant was present for continuance or not, that gets a lot more difficult when you're talking about now for third trial going back to first trial. So I would say I don't know a definitive time when that motion needs to be raised, but it needs to be raised sooner than later, which is our position why it should be raised in relation to the first trial, either on, after that first trial, during that direct appeal. That's the proper time for it to be raised, not waiting until we keep getting further and further down the road. And we have to possibly make some sort of factual determinations based on memories that maybe aren't there, or people are gone, or any number of things that can happen when time spans that far. I don't know if that helps you, but I don't know a definitive time, but sooner than later, sooner than that far out, 10 years down the road, when you've gotten a reversal again and you're going for your third trial. Regarding the sentencing claim, if there are no more questions on the speedy trial claim, it is our position, the issue presented in the Court of Appeals and then granted on petition was whether or not defendant's presumptive sentence, he did receive a presumptive sentence from the district court, whether that was a vindictive sentence or not. The Court of Appeals determined that it was not vindictive. Our position was that it was a presumptive sentence and it should not have been reviewed on appeal. However, the Court of Appeals did go ahead and review it and determined it was not vindictive. Then, after this court granted petition, defendant filed a supplemental brief raising the new sentencing claim that has now been argued, that the Wettrich change in the law, our position is it is a change in the law, that should apply to defendant's sentence. It is our argument that new claim was never before the district court, was never before the Court of Appeals, and pursuant to this court's rules, is not properly raised now for the first time in a supplemental brief.
Why not? If it's truly a change in the law, how can a defendant on a direct appeal ever get access to the benefit of a change in the law if it's procedurally barred? You're saying they can't raise it. How can a defendant ever get the benefit of a change in the law?
I'm not saying they can never raise it. What I am saying is in this posture, we have been in the Court of Appeals, this court granted petition, and now in a supplemental brief, we're raising a new issue.
I'm just asking you, how else was the defendant supposed to proceed to obtain what the defendant alleges is a benefit under a change in the law?
Well, they could raise it, and I understand what Murdoch 2 indicates, but they could raise it possibly in a 1507, possibly in a motion to correct.
Well, wouldn't that completely eviscerate this court's rule that defendants are entitled to the benefit of new law while their direct appeal is pending?
No, and I say that because I'm speaking to this situation that we are at right now, where it's raised late in the game.
Doesn't that depend? You're not alleging any sort of dilatoriness on the part of the defendant in raising it. They raised it as soon as they were able to after this court's decision in Wheatrick, correct?
True. And we also have a motion, we still have pending before this court, a motion to strike that supplemental brief for the very reasons that I argued, that it does not comply with this court's rule because it is a new issue.
Does that just caution that we should remand for the Court of Appeals to consider it before we do?
That's one way to handle it. I didn't think about that. It just, it puts us in a situation, especially since our motion is still kind of hanging out there, where we feel like this has not been an issue that's been adequately briefed to this court because it has been raised late in the proceedings. And I understand what Murdoch 2 says, and it's our position that it should not be reviewed procedurally because when it has been raised.
Do you think that you have not had an adequate opportunity to brief the merits? Is that what you're arguing?
That's one argument because our motion has been pending and we have been waiting to see what would happen there. And possibly, we did respond to the supplemental brief. And so we have made arguments there.
So the state did have its opportunity to brief and argue the merits.
We did, however, we still have a motion. I mean, if this court would have denied our motion to strike, then that also gives us indication of where we're going. And if there was anything else that we felt we needed to respond to with the changes that have continue to happen with criminal history and sentencing and how we are going down this road and where it puts us now with Wettrich. So that's kind of our response to that. Now, if you do decide to get to the merits of this new claim, it's our position that Wettrich is a change in the law. And I understand Murdoch 2 says when you're on direct appeal, you get the benefit of the change in the law.
And explain why Wettrick is a change in the law when it's has a strong constitutional foundation, I think, or whatever the language was, based on Apprendi and DeCamp.
Our position, and I think it's been argued before to this court, maybe last month at length, is that Wettrich is a change in the law because it is said that comparable essentially means identical. And our position is prior to Wettrich, we had Vandervoort and I believe Williams that said comparable was comparable, similar. What's the word I'm looking for?
Closest approximation.
Right. And so that our position is that Wettrich now says that comparable means identical or narrower, and that is a change from what Vandervoort indicated prior to that.
What's the difference between changing the law and clarifying what the law that reads the same, what one of the words means? You understand? We do that all the time. We fine tune and clarify what the plain language means. The law didn't change. The statute didn't change. Our interpretation of the statute, in order to stay within constitutional parameters, clarified what comparable has to mean in order to save the statute, basically.
And I understand that, and I think what helps a little bit of guidance in Murdoch too, this court indicated that Keel was a change in the law because it explicitly overruled Murdoch's first holding that prior out-of-state crimes must be scored as non-person offenses. Now, Keel was also a change in interpretation, but this court says it was a change in the law. We believe it's our position in the same vein that Wettrich is a change in the law.
Because it implicitly, if not explicitly, overruled Vandervoort.
Yes. Yes. So, again, if this court, briefly, is going to reach this new issue, it's also our position that the district court has never looked at this conviction, has never made a Mathis type analysis to see what exactly he was convicted of. If you go to the Mississippi statute, there is an or in there. It's mankind or beast. I've looked at the PSI. All it says is, I believe, unnatural intercourse. We don't know specifically what it was that he was convicted of, and to make a comparison to determine if there's a comparable Kansas statute, I believe the district court needs to look at that. If I can have a couple seconds, it's our position that the Court of Appeals in this case was correct in denying his speedy trial claim and his sentencing claim, and we would ask that you affirm the decision of the Court of Appeals and the district court.
Thank you, counsel.
Thank you.
Mr. Call, before you get started on your rebuttal, could you answer a question, which is on the speedy trial issue, what is the best case you have to support your position on that, whether it's from Kansas or another jurisdiction?
On the res judicata issue or on the actual speedy trial itself? The merits or the...
Why we would be allowed to look at that now?
Well, there's... on the res judicata part of that, there's the Florida Supreme Court case, which I think is on point, that talks about that a ruling from a Supreme Court that reverses is not a final judgment. On the waiver part of it, I was thinking about that and thinking about the court's question about the defendants waive all the time, but they waive their speedy rights all the time. But this court in Brownlee, which is sort of the crux of Mr. Williams' motion, said that the defendant can't implicitly waive his speedy trial rights, and the defendant's counsel can't waive it for him. And that's the gist of it. So I guess I would go to Brownlee on the waiver issue to say that the defendant's counsel cannot waive a speedy trial right for the defendant. And I believe that is the crux of their argument, is that the appellate attorney waived this argument by not raising the direct appeal. And I would urge the court to be, and let me say this, if we've got if it's a factual determination, if the facts matter as far as memories have faded, witnesses have died, I think of that as a laches type of argument. Well, that seems that those are facts that need to be determined by a court on a case-by-case basis. And maybe there are cases where you say you abandon this issue and you're prejudiced. The state is prejudiced by its inability to bring this issue, and so. But that's something that's not what we have here. Here we have the court saying can't consider it, should have raised it in the first appeal. But if it's a factual thing, then maybe you need to send it back to the court. I don't think you should do that. I don't think it matters. I don't think you can waive that argument. But if you're going to say that factually, there could be a scenario where everyone's dead, nobody knows, and so this guy can't get a free pass. Well, those are factual determinants that need to be determined by the district court. And I think you have the authority to say the court was wrong in saying it's categorically you can't raise it, but maybe there are facts and the court should consider that.
Thank you.
Thank you.
Did you have anything else you're prepared to say on
I
rebuttal? You took all your time
seamlessly
answering
worked my intended comments into your question.
Seamlessly. No, it was so seamless, I missed it. I'm sorry.
Oh dear. Thank you, Your Honor.
All right, thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.